Okay, thank you all for showing up today. We have a small subcommittee present at the moment, myself and Chairwoman Taylor, but we're going to go ahead and get this started to honor the Chairman Martin's time and other commitments. We'll start real quickly with just a word of prayer. I'll take care of that myself. If y'all bow with me. Dear kind and Heavenly Father, Lord, we thank you for this opportunity to do the good word for the people of your state. In Jesus' name we pray. Amen. All right, and I'll call to the podium Chairman Chuck Martin to present House Bill 804.
Thank you, Mr. Chairman. I appreciate the subcommittee's indulgence. As you know, Chairman Parsons is out today, and he's asked me to stand in for him in his full committee, which is waiting on me over there. What I've got for you today is an actual House Resolution 804. I don't know if you're getting feedback. I feel like I'm feeding back here. We've seen this before. This is essentially a ballot question, amendment, I believe, to the Constitution that's required to allow loans. I think they're referred to as tax anticipation loans. In paragraph 5, it's temporary loans authorized, but I think we really refer to them as tax anticipation notes to be paid back over a 12-month period and not by December 31st. I have some folks with the Fulton County Board of Education that can speak to this in more detail, but we find ourselves in Fulton County when the tax bills go out, if they're a little bit late, sometimes the due dates for the taxes aren't until after December 31st. As you know, schools count on ad valorem taxes for essentially all of their income that comes from the taxpayer, and it comes in when the taxes are due. So they, from time to time, will take out a tax anticipation note, and that note has to be repaid by December 31st. Well, if their taxes aren't coming in until January, it does little good because they can't take another one to pay that one. That's also in the Constitution, so you can't borrow money to pay the tax anticipation note for another one. So what we're asking for here in the language is to simply allow that to be paid for over a 12-month period. Nothing else is being changed, but just to get rid of the artificial by December 31st. So it would be usable. And again, I have some folks from Fulton County, they can probably talk to the specifics and the details, but we don't think we're hurting anybody. It is obviously a statewide situation, but I think there are probably other school systems that may from time to time run into this, and this could be helpful. So we think we're helping people. We're not hurting them. Folks are going to want to pay those tax anticipation notes as quickly as they can to avoid interest on the system and the taxpayer. I'll answer a question if you have one, or turn it over to the gentleman that's more knowledgeable than I on the subject.
Okay. Any members of the committee that are here have any questions? See no questions. Chairman Martin, proceed to your next meeting.
Yes, sir.
I was going to say, we will hold, since you won't be present, we won't take a vote, but this will be eligible to be called up Thursday.
Yes, sir.
Normally we have our governmental affairs meetings on Wednesday, but we're bumping it to Thursday this week.
Yes, sir. And that was my idea, because I just wanted to make sure that anybody out there, we kind of put this out it's been read in and been out in the public domain, but I wanted it to be heard. And if anybody had a question about it, so I could, if they'd be kind enough to come to me and anybody in the audience or in any of the other government entities, and we'll try to work with them if there's issues. This was the final product that we had a couple of years ago that didn't make it all the way across the finish line, so we're trying to do it this year. Thank you very much.
And I'll be glad to relay anything that comes up in the meeting here to you, sir. Thank you. Okay, do we have anyone? We do have a sign-up sheet, but we just got to put out. But if we have anybody who wishes to speak to the bill, only if you feel necessary. Okay, I see a wave. That's a no. Anybody in support or opposition of the bill?
ACCG supports.
Okay, ACCG supports the bill.
ESBA supports.
Okay. Anyone else? All right. No other comments. Then we will. Again, we have a very small membership of the committee here, but we're not going to take a vote because this bill will be eligible to be called up in committee since we have the hearing today. Especially since there are no controversy surrounding the bill. With that, we will adjourn the State and Local Government Subcommittee, and I'll notify Chairman Leverett that the Elections Committee can come in anytime. So if you're waiting for that, stay tuned. Thank you.
Good afternoon, everybody. We'll go ahead and try to get started here. I'm Rob Leverett. I'm the chairman of the Election Subcommittee of the House Governmental Affairs Committee, and this is our Election Subcommittee meeting. I believe Chairman LaHood is otherwise unavoidably detained, as Carl Spangler-Bentz would say. So we'll go ahead and try to get started. Victor, I didn't give you fair warning. Would you mind opening us up with a word of prayer?
I'll be glad to, Mr. Chairman. If y'all will bow with me. Dear kind and Heavenly Father, God, we thank you, Lord, for the opportunity to come before this body today, God, to represent the people of Georgia, God. We pray for your discernment, God, your wisdom, and your patience as we go forward. In Jesus' name we pray. Amen.
Amen. Thank you, Chairman Anderson. Appreciate that. So we've got two bills on the agenda today. House Bill 1039 with Chairman Hilton, and then House Bill 1112, which is my bill. And Chairman Hilton, we're going to go ahead and hear your bill first. Do we have a sign-up sheet? We do. I see it over there. So if we'll start gathering that. But if you would like to speak to either bill, please just sign up so we know to call on you before Molly retrieves the sign-up sheet. Just a little sort of programming note, as they say. The full committee is on this Thursday at 3 p.m. in 606 CLOB. And these bills, since we've got sort of sparse numbers and technically as a subcommittee we don't have quorum requirements, we probably won't vote on anything today, but they will be eligible to be brought up on that agenda. So, Chairman Hilton, please go ahead and tell us about your bill.
Thank you, Mr. Chairman. Thank you, Mr. Chairman, members of the committee. Honored to be here before you this afternoon, and glad that we'll have an opportunity to talk about this bill, flush out any ideas and potential amendments or anything you may or may not have. As the father of a 17-year-old son, this bill speaks near and dear to my heart, as most children that age and even adults up to our own ages now get a bulk of their news from social media sources, whether it's Instagram, Reels, Facebook, whatnot. So all of us will notice this fall in the presidential race, we're going to see a number of TV ads that say, this is so-and-so, and I approve this message, and it's paid for by such and such. And so this aims to clean up that. The bill is a 2-page bill that says if you are a content creator for social media and you're paid by a campaign to post content, you've got to either verbally or in writing put that on the post. And so what it does is it closes a loop that we have in our law, and it creates more election transparency. So as you're scrolling through videos on your phone and someone says, I think candidate XYZ, Representative Misha Maynor is a fantastic representative, but that content creator has been paid $100,000 from Misha to say that, the voter needs to know that. And so that's what this bill aims to achieve. I've brought Director Amati here. He can talk to some of the other ideas we had in terms of closing loopholes and around this bill, but he's been very helpful to me working on that. Before I bring him up, though, I'll pause for any questions from the committee.
Thank you. You do have a few questions. I think Representative Maynor was first out of
She's asking about that post, that 100,000, yeah.
Yeah, she's not that, she's a little more thrifty than that, but I'll go ahead and let her address that.
Well, look, that it was a public statement, so I'm going to chop it up and put it on social media. I'm just joking. My real question, though, is who is responsible for knowing that law? So would it be up to the candidate that pays the influencer to tell them to do it? Who's responsible?
That's a great question. So if someone in the general population were to say, you know what, I see this video promoting Misha. Sorry to keep using these examples. Promoting Misha. I see on Misha's disclosure that she paid this influencer $100,000, but I don't see the disclosure. They would then file an ethics complaint with Mr. Amati, and that would follow along the normal process. So, the burden rests with the campaign, the candidate, to say, hey, I'm going to pay you $50,000, $100,000 to talk great about me. But, oh, by the way, either verbally, and listen, we aren't the first to address this right now. If you're promoting Tide or Pfizer or, you're paid by a corporate entity, more and more now social media companies are making you either post that on the bottom And so we're just kind of keeping consistent with social media transparency, which I think is good. I mean, frankly, I don't want my son or other people scrolling through and getting, sort of false advertising. So it's sort of a truth in advertising type bill.
Follow-up question? Yes, ma'am. So what if the influencer decides to put it in writing in 0.1 font so you can't read it?
I don't know if I've thought. I mean, I don't know. Do you have the ability to do that?
Well, I guess the reason I'm asking that question is, and maybe he can talk more to it, is even though there is a disclosure, I wonder if we should say it has to have a minimum readable font to it.
Okay. Yeah, I'll happy to entertain that amendment if that makes sense. Yeah.
Thank you.
Thank you, Representative Maynard. Representative Roberts, did you have a question?
I'm backing off, but I'm still thinking this through.
Okay, all right. Just by way of information, and this makes, Mr. Marty's presence now makes much more sense. The 21.537 would go into Chapter 5 of Title 21 in Article 2, which is campaign contributions, and it's under the Government Transparent Campaign Finance chapter of Title 21. So I'm assuming this would be something that could be enforceable by your office. So
Yeah.
that helps sort of clarify.
It's just
things.
interesting as I think back. Gone are the days of Dan Brokaw, or and all, we used to watch the news, and in between they'd have these ads, and it'd say on there, I don't know about y'all, but I spend 90% of my day on my phone flipping through, and we're just trying to add transparency to that. Yeah.
So you're, in a sense, you're not prohibiting the influencer from saying something. You're just requiring they provide a disclosure if they're being compensated for it.
Yeah.
Okay. Thank you. All right, Representative Lallier.
Thank you, Chairman. Appreciate the bill, Rep. I had a question around enforceability. I'm not, knowledgeable of administratively how you would pull this off. I imagine we're going from no one reporting this on thousands of posts to now making it a requirement. How do you foresee the actual administration of this bill?
Yeah, again, the general public would have to make a complaint to ethics against the campaign itself to say, hey, I noticed there's an influencer content creator out there that's putting out a lot of content on this one candidate. I looked up that candidate, and they've got thousands of dollars paid to that content creator. They haven't disclosed that. They then file a normal ethics complaint with the director. And then the normal due process goes from there.
Okay. Yeah, my concern is just administrative feasibility, and I'm still trying to wrap my head around the intent and the motive of the bill. I mean, I don't know how big of an issue this is to rise to the level of warranting this. I'm not against it. I'm just trying to understand the intent behind it, with a big question mark around the administrative carrying out of just the enforceability of it. But
It'd be similar, and we'll address this when you come up about kind of advertising on mailers and things like that. More and more campaign dollars are going toward this type of channel and this type of spend, away from your sort of more traditional type of media. And as that happens, we want to make sure we have this buttoned up, and voters know who's talking to them and who's getting paid to talk to them, and what are they being paid to say. Yeah.
thank you.
Thank you, Representative Lallier. And Representative Roberts.
I'm still thinking this through. So kind of along the same lines as Rep. Lallier, I'm going to be responsible for ensuring that the influencer follows the rules.
Correct.
But yet I have no access to their platform. I'm just trying to think through how that works. When I'm placing Facebook ads, I'm paying someone to design those, I'm approving those, and I'm getting those out. I don't know that you have that. I mean, maybe. It just seems like it's
Your
little bit.
ultimate
and
control. Yeah. Your ultimate control is you can cut the spend and sever the relationship.
Okay. I mean, I don't even. know who's doing this. I agree with you. Like, I haven't seen anyone doing this, and I'm just trying to understand the administration of having to follow up and make sure when I'm in the throes of a campaign, whether or not the person I paid did it the way I told them to do it, and then I could be held, I don't know. It just seems like a lot of trouble for something that I don't know need.
My guess is if you were paying a content creator, you'd engage in a contract with them in which you would spell out, here are the expectations, including you must include this transparency clause.
And do I get indemnified if they fail to do it and I have that contract?
I'll ask Mr. Amati that.
Okay.
If you've got a good lawyer drafting the contract, you do.
Well, but the campaign finance office has to acknowledge that.
Well, they wouldn't have to acknowledge that. You still would have liability, but to the extent you're fined, you would, at least in theory, have a claim for that. I think that's a valid concern about control, but I would my general guess is this would not be the first example of a rule for which we can have liability based on the acts of third parties. That we have at least some sort of ostensible control or opportunity to control. So while I recognize the concern, I certainly think there is precedent for holding us accountable for the acts of others, either in our employ or with whom we contract.
Yeah, I mean, my print shop, I approve like you the drafts, and then I rely on them to print those and send those out correctly. Sometimes they don't, and then you're kind of open to some exposure there potentially.
I think Representative Maynard had an additional question.
Thank you. So I'm going to use Taylor Swift as an example, only because we've been using Taylor Swift as an example in regulated industries so much.
This has nothing to do about tickets, by the way, for anybody who's on regulated. Yeah.
So I paid Taylor Swift money to say that I am a great candidate. I will provide Taylor Swift a contract, and in the contract it says you must make a disclosure in writing or verbally that I paid you to say I'm a great candidate. Now, I have that contract. I can show the campaign ethics committee the contract if something goes awry. But if Taylor Swift chooses not to do what the contract says, now I can sue Taylor Swift because she didn't follow my contract.
Politically, I wouldn't recommend suing Taylor Swift, but again, and Director Amati, I don't know if you want to go ahead and come on up because he's a very benevolent man. I don't, if that happened to you and it was Taylor Swift, he may let you off, but
I like the bill. I just want to know how, we want to make sure that it's all the way wrapped up in the loop.
Yeah.
This is what we refer to as the lifeline or phone a friend option in the election subcommittee.
Yeah, does Director Amati want to come up? No, was the answer. And I apologize, I'm not wearing a tie. I thought I was Chairman Gaines on a Friday and I had the day off, but I got called over by Representative Hilton. To one of the questions, I'm sorry, I know there are a couple questions that got thrown around there. One of the questions that was addressed earlier, this is not an altogether new concept in campaign finance anywhere or even in this state. So if a super PAC, an independent committee, or a leadership committee puts out a mailer advocating politically for one candidate, they by law already have to disclose that it was paid for by this group. This is just extending that idea to sort of a third party that the campaign has control over what they're saying. And I think that was kind of the intent, but it's not a new concept altogether. So from an administrative standpoint, it'd be no different than if a super PAC put out, $50,000 worth of mailers and didn't disclose that they paid for it. There's already a mechanism for us to deal with that. And Representative Maynard, you had another question that Mr. Hilton was.
In regards to the contract, if Taylor doesn't abide by the contract.
Why don't you just grab the mic real quick so
Yeah,
our watching at home audience.
Hello, watching at home. If Taylor doesn't abide by the contract, then you as a candidate, are you liable for any ethics violation?
So the current reading of the proposed language would be yes. Now, there's a difference between liable and punishment. And I like to think that, at least while I've been here, we've been pretty reasonable about if you're doing everything right, someone else does something wrong and you try to stop them, we're not going to be unreasonable in that regard. As far as you suing Taylor Swift, and again, I am on the record not in favor of suing the Swifties, that would be a contractual sort of claim you have in the contracts world. That's not really an ethics commission issue. That's maybe more Chairman Leverett, as outside counsel, might be able to advise you on. But you would presumably have some recourse in that contract.
All right, I mean, Chairlady Taylor has been very patiently waiting on me.
Thank you. I thought I had this clear in my head until everybody started talking about it. Okay, if I get an endorsement or somebody, Mickey Mouse, says, yes, this is a great candidate, vote for him. If I pay them, this has to be disclosed by both of us, and it has to be stated when they make that announcement. If I don't pay them, they just like me, then it doesn't matter.
First Amendment.
Thank you.
All right, any committee members? Chairman Hill, I don't know if you had some other comments you want to make to close out, or?
Yeah, I mean, again, I would just say, it's interesting, we talk about mailers. Nowadays, folks with followers of 2 million plus, you're getting a lot of eyes on things, and we're just trying to, put some sunlight on. Some of these folks are getting paid to say good things, and so voters know what they're consuming.
Yep. Again, I think it's you're not really restricting the use of that device, for lack of a better word. You're just requiring disclosure, yep. so the public knows. Yep. Anyone on the committee have any other questions? All right, thank you.
Thank you.
And thank you, Director Romano. We appreciate your being here today, too.
Appreciate you. Thank you, committee. Yeah.
All right, so, again, I think we're just doing hearing only today on these two bills, so but the bill will be eligible to be on the full committee agenda this Thursday at 3. All right. Did anybody else want to be heard on that bill before I move away? I don't think there was anyone on the list, but I just want to make sure. All right. Thank you, Chairman Hilton. Okay. Thank you. All right, and the next issue next bill on the agenda is House Bill 1112, which is a bill that I filed. And I thought we would just have a hearing on this today to sort of make sure everyone's aware of what we're trying to do here. And I believe General Counsel McGowan is here on behalf of the Secretary of State to speak to the bill. So we appreciate you being here today with us. Thank you for taking your time. So there's a similar bill pending in the Senate, Senate Bill 358, that was filed by Chairman Burns. Our bill is a bit different, so I'll just sort of walk through it. And I think the genesis of the bill was actually a conversation I had with one of the members of the State Election Board relating to the recent controversy a few months ago about whether that board has any investigative authority over the Elections Division. And also he mentioned to me a new sort of practice or device the board was utilizing that I thought sounded like a very positive kind of tool. It wasn't so much about punishing people who make mistakes as about giving them instruction. So we put that in. And there's also some provisions in here that kind of follow up on some changes we made last year that make the State Election Board, I would say, more independent, or at least give kind of avoid any appearance of any improper influence or structural possibility for that influence, so they can be more independent. Our Secretary of State has come under fire quite a bit over the last few years, and I'm assuming he sometimes feels like he's sort of being besieged on all sides. It was my hope that the State Election Board could be a potential source of instruction or direction, and by having some investigatory power could also, in some cases, provide instruction, sort of provide that oversight, but also, if he's doing things right, confirm that. So we've tried to draft it with that goal in mind. So just kind of walking you through the bill, Section 1 addresses provisions on the sort of the structure of the State Election Board. We removed the Secretary of State as an ex officio non-voting member. He was a member. He was then made non-voting ex officio. Now he's just would be taken off that board again to give or to avoid any sort of appearance of any kind of improper influence. Not that it would be exercised, but we're talking kind of about just public appearance here. Then we make some sort of technical correction in line 21, which would follow from his removal. And then in lines 26 through 31, we're amending the provisions that were enacted, I believe, last year, where he was made, where the board was made a separate and distinct budget unit, but instead of being still within the Secretary of State's office, it would go into the State Accounting Office, which is actually a similar structure to the Ethics Board, which Director Amati was just here recently, so that's kind of an interesting coincidence. So it's kind of moving towards some of that general structure. And then there is a provision in the bottom of section 1 in lines 32 through 38. That paragraph 2 is actually a part of subparagraph K, which gives powers of the executive director of the board. There's another paragraph in that section that authorizes the board to hire an executive director, and that paragraph 2, which subparagraph 2, which appears in 32 through 38, just confirms that the executive director can employ and fix compensation of personnel. It clarifies that that could include investigators, and then it sets out that the investigator should have some expertise and experience with regard to elections, but the board can work out the specific parameters of that. And then in L, to avoid any other question, it just confirms that the board can also hire investigators to conduct investigations that are authorized by the chapter. Section 2 of the bill has a provision which clarifies, this is sort of the crux of the dispute that the state election board experienced a few months ago, to say that the board would have the authority to investigate not only just local election officials, but the elections division. We tried to choose that language because it did not say the Secretary of State himself. It's the division that administers elections. Again, it is not my intention to add to the degree to which the Secretary feels besieged. This is not directed at him personally. It's just directed toward the administration of election laws. Then in section 3, this relates to the conversation I had with the our board member, that they are now issuing letters of instructions and letters of reprimand. I'm not aware of any statutory authorization for that. I'm not aware of any statutory prohibition of that. But I like the thought of collaboration and instruction. Not so much, punishment or seeking to censure or embarrass, but to instruct so that everybody in the state, local election officials and people in the Secretary of State's office, have some kind of guidance on issues that may be unclear or uncertain. So we did, I suppose, two things. One, we specifically provide that the board can issue letters of instruction and letters of reprimand, and then we try to sort of say, well, what's the difference between them? We're somewhat winging it with this definition, but the idea is a letter of instruction is appropriate when someone acts in good faith and just gets it wrong. And it's understandable. It's sort of excusable. It's understandable that they may not have understood. Maybe the law was unclear, or there was a conflict. That would be a letter of instruction. Letters of reprimand or when a violation occurs and it's not quite as understandable. Either anything from just, well, it was gross neglect to bad faith. And then the board would have the ability to further define what those, when each of those is appropriate. And then section 4, I think, just follows from the removal of the Secretary of State from the election board itself. This was the 21-235 is the code section that provides some limitations on the board's ability to adopt rules on an emergency basis. And there were some notices provided in that statute to certain elected officials. And if the Secretary of State's not on that board, he ought to be one who also is entitled to one of those notices as well. So we added him to that. So that, again, is sort of the gist of the bill. Now, I should say, General Counsel McGowan is not here to endorse my bill. The Secretary of State's office opposes it, and I respect their position and wanted people to have the benefit of their position. So I notified them so they could be present, and I know General Counsel McGowan has an extremely busy schedule and many duties to tend to, so I greatly appreciate her attendance here today. And I was going to go ahead and recognize her so that she could give their position, and then I don't think we've got anyone else signed up on this bill to speak. So General Councilman, if you'll come around to the podium. And we're, again, appreciate your time today and appreciate your presence here. Thank you. Just whenever you're ready.
Thank you, Mr. Chairman, and to the members of the committee for allowing our office to have our voice heard and allowing me to speak to you this afternoon. I do want to clarify that our office is only partially opposed to HB 1112, and the partial opposition is limited to Section 2 of the bill, which is the section that authorizes the state election board to investigate the Secretary of State and the Elections Division. We don't have opposition to the other parts of the bill, although I'm certainly happy to weigh in to the extent that the members of the committee have any questions. And there are just several significant legal and policy issues that I wanted to make the committee aware of as you consider whether or not to move forward with this bill. Our office did send a letter out to the members of the General Assembly talking about the concerns, the legal concerns that we have. So hopefully all of you received that. If you didn't, I would be happy to forward it to your attention. But I just want to hit some of the highlights. Our office's primary concern with the bill is that it would violate the Georgia Constitution if enacted, and specifically that it would violate the separation of powers that we have in our state constitution. The Secretary of State is an executive constitutional officer who is elected by the people of Georgia. He is the chief elections official in the state, and he has constitutional responsibilities over the area of elections. And so he is accountable to the people directly. And that is the highest level of accountability that you can have when you serve in government. The State Election Board, on the other hand, was created by statute. It is not in the Constitution. And the members are all volunteers who are political appointees. The board's authority is limited by statute. And again, the members are not elected and they are not directly accountable to the people of Georgia. And so, as I mentioned, it is our opinion that this particular proposal would be unconstitutional, but it is not just my opinion. There is actually an official Attorney General opinion that directly addresses this issue. And that opinion says that there is nothing in the law that allows the State Election Board to oversee, investigate, or otherwise control constitutional officers, such as the Secretary of State. This opinion goes on to state that the Secretary of State is the officer, the constitutional officer, when it comes to overseeing elections in the state of Georgia. And there is, to quote the opinion, it says, there is no indication in the law that the constitutional and statutory authority of the Secretary of State should be limited or substantively controlled by a board of political appointees who are not accountable to the electorate for their actions. So again, the Attorney General opinion goes on to conclude that to give the State Election Board any sort of oversight over the Secretary of State as a constitutional officer would violate the separation of powers. The second legal issue with this proposal is that there's really no means to enforce it. The State Election Board can only take legal action through the Attorney General's office. And the Secretary of State is one of the clients of the Attorney General because they represent all state agencies and state entities. And there's nothing in the law that permits one state entity to take legal action against another state agency or entity. So again, I'm not aware of any precedent of any sort of unelected board or commission in the state of Georgia that has this kind of oversight authority over a constitutional officer. And just as from a policy perspective, we hear a lot lately about the weaponization of the administrative state in Washington, D.C., and how it can be used to interfere with elections. And I think that criticism is fair. And so my question would be, why do we want to bring that to the state of Georgia? And I do appreciate, Mr. Chairman, your comment that this isn't necessarily really to criticize or oversee the Secretary of State, and that one of the goals might be to allow the State Election Board to support the Secretary of State in his efforts. And I do appreciate that comment, but there's really nothing that prohibits the State Election Board from doing that already. In fact, many of the members have been very supportive of the Secretary's office, and we appreciate the support that they gave us in the 2020 election and their defense of the state's administration of that election in 2020. And my concern with this proposal is that it is really just going to be used as a way to weaponize the state election board to either relitigate what happened in 2020 or to try to interfere with the election that we have coming up in 2024. And the Secretary's sole focus is on 2024 and making sure that we once again have another successful election, and that that election is secure and safe, and that the voters of Georgia are able to exercise their right to vote. We want that to be done with integrity and free from political interference. And so the risk with this bill is that we feel like all election officials should be focused on 2024 and making sure that that is a smooth election. The risk here is that this is going to inject needless hostility between the Secretary's office and the state election board, when all election officials should be focused on making sure that we work together in partnership and collaboratively to make sure that 2024 is a success. I also just want to conclude by praising the Secretary of State's Elections Division. I have had the pleasure of working with them for a year now, and they are, without a doubt, the hardest working and most dedicated public servants that I have ever had the pleasure of working with. They are experts in their field. They have decades of expertise in election administration, and I also have great respect and admiration for the members of the State Election Board. I have enjoyed working with them. I worked with them when I was at the Attorney General's office, where I represented them as my client. So I have worked with both the board and the Secretary of State's office for a number of years now, and appreciate their partnership and collaboration. But that being said, the members do have varying degrees of expertise in elections, and as opposed to the Elections Division that has decades of experience. They don't always see eye to eye in interpretation of state law, and so there would be really no way to reconcile if there was a difference of opinion between the Secretary's office and the State Election Board. So again, my request to the committee is that you emphasize that the Secretary of State's office and the State Election Board should be allies and partners and not do anything that would inject needless hostility into that relationship. Just in closing, I have heard in support, at least to the Senate bill, some arguments made in favor of that. One, comparing this to the Ethics Commission, and we heard from the Ethics Commission just a minute ago. And the important distinction there is that they regulate candidates, not executive officials that are performing their executive duties. They are regulating what they do as candidates. The other thing that I have heard this compared to is the JQC, which is actually in the Georgia Constitution, and it is sort of a disciplinary panel that oversees our judiciary. And they make recommendations to the Georgia Supreme Court, who can then take disciplinary action against members of our judicial branch. And again, so this is not comparable because that is actually in the Constitution, and so the Constitution allows this particular commission to regulate constitutional officers such as our judges, whereas, again, the State Election Board is not a constitutional body. Again, thank you, Mr. Chairman, for inviting me here to speak, and I'm happy to answer any questions.
Thank you, General Counsel. I think you do have one question from Shirley Taylor.
Thank you, Mr. Chairman. Just a couple things were going through my mind. It does not include any disciplinary action in here. There's nothing that this commission does other than investigate. Is that correct?
That is not correct.
Okay.
It is in the Elections Code that gives the State Election Board the authority to not just investigate, but also take civil enforcement action against.
They would recommend it to go to either a local district attorney or to the Attorney General. Is that correct?
That is correct.
They don't take any action. There's no penalties that they can give. They would just turn whatever investigations they find or information they find to someone else?
That is part of the process. So when the State Election Board hears a case, they can take a number of different actions. They can, as you mentioned, refer it to a district attorney for criminal prosecution. They can also send it to the Attorney General's office for civil administrative action. And what happens there is that the matter is taken to an administrative hearing before an administrative law judge. And once that administrative law judge makes a recommendation, it then goes back to the state election board for a final order. So ultimately, it is the state election board that has the final decision whether or not to impose any sort of civil penalty against a respondent.
Okay, and one, I will say, I've had a constituent actually ask me, who is overseeing this, whole process? They have concerns. We've all heard concerns about it, but this is one of the things they said. It may be more than just decisions that were made. They question a lot of things that happened. I'm sure you're aware of, I don't want to air everything that everybody complained about, but their concern is, where do you go? Who can you complain to if you don't go to the election board? Where do they go? Who can be the oversight? I guess that's what they're wanting to know. Does it come to the legislation? Do we have to have some kind of hearings like they do in Washington if we want to question or challenge something? Or is this I think was something that would take the place of something more intense than that?
Are you speaking of specifically complaints against anything the Secretary of State's office
The
has
Secretary of
done?
State's office, yes.
Okay.
That's what their concern was. They had lots of inquiries and complaints, and their expectation was, as their legislator, they came to me. They wanted me to do something about it. And that might be where this legislation came from. But what recourse is there for somebody that wants to question or investigate how things are being done in the Secretary of State's office?
There are a number of ways that the Secretary of State's office does have oversight. One of them is the Office of the Inspector General, which does have oversight authority over certain elements of executive officials. They can look into how we spend money. We are subject to audit. They can look into, ethical complaints about the office. Georgia citizens also have the ability to seek recourse in our court system. And that's how a lot of our, that is one of the checks and balances that is in our state constitution. And a number of legal challenges have been brought over actions of the Secretary of State. Specifically to 2020, we saw 20 of those cases brought in state and federal court, and the Secretary prevailed in all of those. So there are certainly checks and balances that our Constitution already provides for our constitutional executive officers, and we are just asking that the committee respect those checks and balances and not add additional oversight that would violate the separation of powers in the Constitution.
Thank you.
And I will also add that we certainly want to have a dialogue with the General Assembly to the extent that there's concerns about decisions or actions that were taken. We certainly want to have that communication with the General Assembly and are happy to take questions and meetings about decisions that we make.
Thank you. Representative Maynard, did you have a question? I would, if I might also just comment, I think the sentiment that Chair Lady Taylor is hearing is part of what led to my filing the bill. I feel like there is a feeling that there is no really accessible means of having further examination of these issues. And this would be sort of a pressure valve that would give citizens a reasonably accessible means beside having to file a suit against the secretary. To have the state election board look at it, see if everything was done right, or if maybe they feel that the law should be interpreted differently and something different could be done. I certainly would not intend for this to lead to hostility between these branches, and I've tried to be careful in the way we drafted this so it did not encourage that. I know that's a risk, but that's kind of a risk of any oversight system we try to set up. So, and I would just say, as to the constitutionality, you are correct. There is an AG's opinion, which I think is based partly upon statutory construction, which I'm proposing to change here. And they do reference constitutionality, although that is an AG's opinion. Thus, it is not it's not like the same as a case. It is an important opinion. It's a very persuasive one, but I think we've got, at least, I believe there is a valid argument to say that it would not be unconstitutional. But yet I acknowledge that is not a absolutely clear issue, I would say. And I'll let you respond to that if you'd like to.
Yeah, so I didn't bore you with a legal memo or brief. I would be happy to provide a more substantive argument on the constitutional issue. I was just trying to hit high level just to make the committee aware that there is an attorney general opinion out there, but I do think there is also a good deal of Georgia Supreme Court authority on the issue of separation of powers, not specifically to this particular issue, but I think the Georgia Supreme Court has expressed a commitment to the separation of powers in the Constitution when it comes to executive officers, and I'd be happy to provide you with additional legal precedent.
And I certainly don't disagree with that statement. I disagree in the terms of whether it's specific intersection with this particular structure I'm proposing here. But I acknowledge your opinion, which you very capably stated. I think in a letter you sent to the General Assembly in response to Senate Bill 358, I think.
Yes.
Because the language in 358 is very similar to my language. Mine is a little different, but it talks not about the office of the Secretary of State, but about that division of the elections division. So not the elected official as much as that particular office that's charged with overseeing elections. So
I see. I think you can respect, though, that those particular individuals are state employees who are hired by the Secretary of State and overseen by him. And I think there could be the possibility for tension if they feel like they have two bosses. You know, one being the Secretary of State who actually did employ them and is responsible for overseeing them, and then this political body that I think, you know, out of respect to them, I want them to have clear direction, especially going into 2024, and not have them conflicted as to, you know, how they should be performing their job duties, and respect the Secretary's authority as the one that does oversee the agency.
And I acknowledge that concern. There was one other. I know. Well, I think Representative Maynard has a question. Let me get to her.
Thank you, Chair. My question is, thank you for the presentation. My question to you is, in your opinion, if the Elections Board did an investigation, would it be more appropriate for it to go to the investigative report to go to the Inspector General's office, who is already has the authority to investigate the Secretary of State's office over the State Accounting Office? Is that what you're saying?
No, my argument is that to give them the investigative authority over the Secretary of State's office is what would offend the Constitution, and that is what we are opposed to, not the particular agency that the matter would get referred to. I believe the language about the State Accounting Office in the bill is in reference to the particular state agency that the State Election Board would be attached to. And right now they're attached to the Secretary of State's office for administrative purposes.
And then a follow-up, if I may.
Yes, ma'am.
The follow-up question is, and this is where the attorneys are proficient, so I'm not an attorney, which is why I'm asking the question. Right now, currently, the Constitution defines the roles of the constitutional officers, and if this bill became law, then it is restructuring the Constitution. So to say that it does not oblige the current Constitution is not the same as if this changes, because now the Constitution has been changed.
I think that is correct. I think that's another way of saying what I was trying to express previously was that the way this bill is written would offend the current structure of the Constitution. I think you could probably get there maybe if you amended the Constitution to create this entity that had this type of oversight authority. But again, I think that would require a constitutional amendment to, you can't alter the structure of the Georgia Constitution by statute.
Okay, and then one last question, if I may. Georgia Code, does the Constitution or does Georgia Code identify the roles and responsibilities of the constitutional officers?
It's both. So the Constitution is very high level when it comes to the roles and responsibilities of the state constitutional officers. As I mentioned, it does give the Secretary of State certain roles when it comes to elections, the main one being the receipt and certification of election results. That is in the Constitution. then it does allow the General Assembly to further define what those roles and responsibilities are for all of the constitutional officers. And you will see that for many of them, whereas they have their general role defined in the Constitution, and then that is supplemented by code, by statute.
Thank you. You answered my question.
Representative Bazemore.
Thank you, Mr. Chairman. Thank you so much for your presentation and allowing us to hear what this bill would do. And I think one of my questions was going to be in relationship to the Constitution. So basically, if this passes, you're saying that we would be violating the Constitution because we would have to change the Constitution in order to get this done.
That's correct.
Okay. And I'm not totally against the bill. My concern is one that you raised about the individuals on the board are politically appointed. That's my concern. So thank you for the bill and thank you for the explanation. Appreciate it.
Yeah, and that's an important point. And when we talk about the separation of powers, our Constitution is pretty clear that the people of Georgia are to be governed by the people that they elect. And so that's part of the problem, is giving that kind of authority to unelected bureaucrats, really. Sorry to use a word that I know is kind of a pejorative these days, but the Constitution provides that the people are supposed to be governed by the officers that they elect, and the state election board does not meet that criteria.
And I'm sure they'll all appreciate your reference to them as bureaucrats.
I'm sure they will.
We'll just say for you that you mean it in the most positive sense of the word.
I
I'm
do.
Sure. Okay. Representative Roberts, did you have a question?
Thank you, Mr. Chair. I guess I'm just trying to think if there's another example of a constitutional officer and a board like the state election. Is there any other example of that in our government where it's kind of this blurred role of who is investigating and who's doing these roles? Do you understand my question?
I think I do. I'll do my best to answer it. I'm not aware of any board, one that has oversight authority, obviously, over a constitutional officer. I think this.
The Prosecutorial Oversight Commission that was just approved, I would argue, does, but we'll let that go.
Well, and that has been the subject of past legal challenges.
Correct. And the Supreme Court raised questions about the constitutionality of it, but.
I'm not aware of any.
I'll remind
sure
you this is the elections subcommittee. So.
I know.
There are, again, as the chairman mentioned, I do work for the Secretary's office, and I have some background in representing state agencies, but I'm not aware of any board. There might be some boards and commissions that are designed to supplement the roles of other executive officials. I think the way the state election board, when it was set up, obviously the Secretary of State was the chairman of it, so they were designed to be interconnected. And I think that is good from a policy perspective, that you have all of the elected officials working in partnership together. So I think this structure is a little bit unique in that regard. And to the extent that the General Assembly makes the policy determination that they want the state election board to be more independent, that is certainly up to you. We just want it done in a way that, again, encourages partnership and doesn't put oversight by this political board over the constitutional officer.
Thank you.
Thank you. I think Representative Maynor.
Thank you. Thank you, Chair. I think earlier your example was the Judicial Qualification Commission. That was an example of a board that has oversight over a constitutional officer.
Yes, and my point was that I have heard that used as a justification for this proposal, at least for the Senate proposal, and I don't think that is a fitting example, again, because that it was established by constitutional amendment that established this commission that has some sort of disciplinary oversight over our judicial branch. The Supreme Court of Georgia does make final determinations, but I don't think that you can equate the state election board with the JQC, because the JQC is a constitutional board or commission.
Thank you.
Chairman DeLoach.
One quick question. Help me understand, under the current law, if this state board of election came across information that would indicate that either the Secretary of State or somebody in the election division had done something they believed to be improper or even illegal in an election process, what action should they take?
So I think the Attorney General's office does have the ability to investigate wrongdoing by elected officials. I think that is something where if they became aware of something, they could certainly send the information over to the Attorney General's office for them to make the determination whether or not to look into the matter. So that is a possibility. Again, our opposition is just to the way the bill is structured, in that it does put the state election board in an oversight position over the Secretary of State's office.
May I follow up, Mr. Chairman?
Yes, sir, please.
So then what you're telling me is that the Attorney General's office has some authority to investigate and, if necessary, bring charges against the Secretary of State?
I don't know if bring charges would be the exact terminology that I would use, but they do have investigative authority and can, if they find, and they do have a public corruption section, and so if they find that elected officials are engaging in wrongdoing, they can certainly take appropriate action. I would think that would be more of a criminal nature rather than.
Thank you.
Thank you, Mr. Chairman. Yeah, I would add, I don't know that it's fair to ask a lawyer how best to punish her own client for misconduct. That's putting her in a tough position. But I will say that concern is part of what led to the bill. I recognize you have a constitutional objection or concern to it, but that is sort of the tension or the steam in the pot I'm trying to find a resolution for here. So I believe Chairman Blackman was next year.
Really, Chairman, you can probably clear this up, but like it's my understanding the Attorney General also represents the Secretary of State. Okay, all right, so that may have been your point.
I would think the General Counsel is probably more capable of answering that, but I think generally with respect to some matters, the Attorney General's office does represent the Secretary of State.
Yes, they serve as legal counsel for state agencies, and I'd be happy to look into your question more specifically and get back to you rather than trying to speak off the top of my head, which sometimes gets me in trouble. So I'd be happy to look into that and provide you some additional information. But yes, you are correct that the Attorney General's office does provide legal counsel to both the State Election Board and the Secretary of State's office.
I just felt like that spoke to my colleague, the representatives, potential conflict there, I guess you would say, in a situation such as that. But,
right, and that's why there's also additional Attorney General opinions that counsel against state entities taking legal action against each other, because the Attorney General's office is supposed to serve as counsel for both, and they don't want to create those conflicts when it's not necessary.
Sure.
Thank you, Mr. Chairman. Representative Maynard.
Thank you, Chair. And I guess I just want to kind of reflect off of what Representative Deloach just said. He asked you, well, what is the recourse if someone believes something was not done appropriately? And your response was they could potentially take it to the Attorney General's office. But then earlier, when you presented, you said that the Attorney General's office really is somewhat conflicted out of being able to do that because they represent the Secretary of State. So just agreeing with my colleagues here that the statements are contradictory. If there's a problem, one sentence is you can take it to the Secretary of State, but then the contradiction is, oh, you can't take it to the Secretary of State because, you can't take it to the Attorney General because the Attorney General represents the Secretary of State.
Again, there are ways that if a state official has engaged in a criminal act or other act of wrongdoing, that there is a way to have that investigated. And I'm happy to provide the committee with additional information that answers that question specifically.
Well, and if I could make one comment, I don't know if you have a follow-up, Representative Maynard. General Counsel McGowan mentioned there is the Inspector General, which has jurisdiction over the executive branch. Again, though, I think as I understand that office, that's limited just to basically misappropriation of money and things of that nature. So it wouldn't apply to the manner in which election laws are being administered, which has been sort of the discussion that we've been having the last few years. And so I feel like this would provide a means for that discussion at least to occur. But I mean, again, if it's unconstitutional, it's unconstitutional. But I would just urge members of the committee to keep an open mind on that issue, because I do believe it would be constitutional. However, we have a difference of opinion on that at this point. So I was trying to think, to your point, is there another statewide elected official with a board? I do know the school superintendent does have a board as well. I'm not exactly sure what authority that board has over him, but that might be something we could take a look at. In addition to just generally, I mean, I think I respect your opinion, so I think that is an issue we need to, or at least that I need to look into with respect to the bill. But
I believe the Board of Education is established by the Georgia Constitution.
so it's a constitutional board, so that probably would distinguish it. Yes. So, and I think, to be fair, you've sort of been very kind in that I think you're basically objecting to Section 2. But from our discussion, I don't think you particularly think any of the bill is particularly good from a policy perspective. Is that fair?
I have concern. I don't have any objection to, I think it's Section 3, where you are authorizing the board to issue letters of instruction or letters of reprimand. I think that is, certainly don't have any objection to that. I actually think that is good policy. And I think it's something that the board has actually done as a matter of practice. Anyways, they do issue letters of instruction when it's something that's more of a mistake that's done by a poll worker. You certainly don't want to penalize that poll worker when it comes to like a monetary civil penalty, whereas a letter of instruction might be more appropriate. So they do frequently issue those, especially to our county election officials. And so I think we would certainly support Section 3.
Okay. All right, let me take one more question. I think we'll try to wrap it up. Chairman Deloach.
One more thing. Can you tell me what authority the General Assembly has to investigate and subpoena and look at constitutional officers in the state of Georgia?
That is not an issue that I have researched for purposes of this particular bill, but I'm happy to look into it.
Thank you.
As Judge Hurd, my father's senior partner, would say, you'll find that the members of this committee have very agile minds. So forgive us for peppering you with these legal questions. Chairman Blackman.
It's probably already been answered. I apologize if I'm re-asking. But so, with the state election board having, not only kind of a rule-making authority, but also more of a, judgmental, judiciary responsibility. Is there, then you have, I guess, previously where the secretary was the executive also. You understand, so maybe how all that doesn't necessarily create a separation of powers that would be, usually considered, appropriate, generally speaking. But I wondered, from you're saying that it's a different type of scenario. I just wondered if there was anything else that operated and functioned that way, just other boards or other entities potentially.
I'm sure there are other boards and commissions that operate in a quasi-judicial way, like the state election board.
Probably so.
I'm sure there is. I don't know if I'm answering your question or if I understand your question. But yes, I would agree that the state election board, at least with respect to their enforcement authority, operates in a quasi-judicial manner in that they do have the authority to impose civil penalties that are subject to judicial review and take that sort of action and to hear cases. So they do operate in that sort of function.
As well
but
as
again,
the
it's not, and they do have rulemaking authority. Yeah. But again, the Secretary of State, being a constitutional officer, and being a statewide elected official who's accountable to the people, does have that particular authority that isn't subject to oversight by a political board.
Any follow-up?
No, thank you. You answered my question. Thank you, Mr. Chairman.
All right. Representative Roberts.
Real quick, did I mishear you back on the accountability issue? And you talked about if there was some sort of fiscal, you could go to the Inspector General, those other options. But didn't I also hear you say there were 20 lawsuits challenging the election? So what were these mechanisms for these 20 lawsuits? How did they bring those under what type of action?
We saw two types of action. There were our election contests, which were filed, which were challenging the results of the 2020 presidential election. There were also lawsuits brought in state and federal court that were also seeking injunctive relief to either stop the certification or decertify the results of the presidential election. So we saw both of those types of cases. There are also other ways. That was specific to 2020. But if the committee may recall, back in 2021, the voters of Georgia approved a constitutional amendment to waive sovereign immunity for state officials, a limited waiver of sovereign immunity that allows citizens to bring actions for declaratory judgment against state officials challenging a rule or practice, or I should say, a practice or a decision of a state official. And so that type of recourse is also available.
Right.
And we have seen those types of cases brought as well in our superior courts.
Okay, thank you very much.
And I would add, while that's certainly true, we always have mandamus and resort to court of equity. There are other alternative remedies that are afforded by the law in other contexts, and that's kind of what I'm trying to do here.
Right.
So again, we still do have the issue raised of constitutionality, but to me, the presence of a judicial remedy does not necessarily preclude other alternative remedies that the legislature might structure, provided we comply with the Constitution. So, Representative Maynard.
Thank you again, Chair. Out of those 20 lawsuits that were brought, were any of them brought by the state election board, or the public brought those lawsuits?
Both the members of the public as well as candidates.
But not the state election board?
No.
Okay, thank you.
All right. I'm going to make hay while the sun shines. I don't have any lights blinking on the board, so I think I'll go ahead and call it concluded. We don't have any other folks who want to speak. Did you want to speak to the bill? Yes, you may. Thank you, General Counsel McGowan. I appreciate your time. Thank you so much.
Thank you for having me.
Did that the easy way. Thank you, Mr. Chairman. I'll be very brief. I was there in 2007 when the Secretary of State's Inspector General's office was set up. Ever since that time, it was designed to conduct election investigations, but they have been politicized ever since. The investigations need to be moved. One of the things that, while we support this bill, but one of the additions that need to happen is that all investigations need to be moved from the Secretary of State's office to an independent body, which is the State Election Board. We tried to get this last year with Chairman Gaines. It didn't quite get through, but I'd ask you to consider that as an enhancement to this bill. Let me give you one example very quickly, since I only have about a minute. The Dominion Democracy Suite 5.5 system has a ballot rejection problem, very severe ballot rejection problem. The investigators told the court in the Curling v. Ravensburger case just last month that there was no problem. And they basically admitted, though, that they never investigated when they were cross-examined. That the State Election Board complaint, which is there right now, has audit logs showing that problem existed in 65 of 67 counties in the state of Georgia. And it was the same problem that the Tennessee Secretary of State used to discontinue use of the same system that we are using here in Georgia. Now, all of that is being withheld from you as Secretary of State because by the Secretary of State, because you cannot really actually get the truth unless you have them under cross-examination. And that is why the investigations are way too politicized. They need to be moved to to the State Election Board, an independently funded body, so that we can get the truth, and then your constituents will not be as upset as they are right now. Thank you very much.
Thank you, Mr. Favoreto. I don't believe you have any questions, so thank you for bringing that to us. All right. Well, I think, again, this was just a hearing only. I think we'll sort of keep studying this. Ms. McGowan will try to continue the dialogue with your office. And I appreciate everyone's attendance here today. Appreciate all the members with the good questions. So unless there's anything further to come before the committee, we'll declare it adjourned. Thank you, everybody.